favor, the propensity evidence rather, in favor of the probative value versus any undue prejudice. And I did not, while counsel objects to sort of the fact that they were in fact minors, there's not really a lot addressed as far as why they wouldn't be admissible under that particular statute.
Let me interrupt you
Sure.
for a moment. Under MCL 768.227A,
Yes.
it indicates that in a criminal case in which the defendant is accused of committing a listed offense against a minor, so that would certainly apply, at least with regard to the charges to this case. Evidence that the defendant committed another listed offense against a minor. Right?
Correct.
A listed offense is defined as a crime that's in Section 2 of the Sex Offender Registry Act.
Correct.
Here, the two complainants you're asking to admit under the statute would be Mr. Griggs and Mr. Hill.
Yes, Judge.
Mr. Griggs' allegations involve penetration.
Yes.
Mr. Hill's does not.
Correct. It involves other forms of sexual misconduct, as outlined in the brief.
So what crime of sexual misconduct for Mr. Hill are you saying is a listed offense?
The solicitation of the pictures, the pornographic materials, showing it to Mr. Hill, then asking him to send the pictures on the phone, that was in fact part and parcel, as well as the theory under the ones, which I'll address with the 404B, that grooming, that soliciting, that underlying felony that escalates the 3 to the 1. But as far as just what misconduct we're talking about, it's that specific act.
So it's accosting or soliciting a minor for immoral purposes,
Yes, Judge.
which is a Tier 2 offense
Yes.
under the Sex Offender Registry Act, which makes it a listed offense. Is that right?
Yes, Your Honor.
All right, go ahead.
Okay. And under the Lincoln-Watkin case, it talks about weighing it in favor of the probative value, and I think based on the extensive facts that we provided the court, I think the probative value is overwhelming. And Watkins also talks about if there is any conflict between 404B and the statute itself, the court should weigh in favor of the statute. I think the only conflict that would exist is for what purpose the people can introduce it for, and whether there be a limiting instruction or not as to those witnesses. Obviously, if it's introduced under 404B, we would support a limiting instruction for the trier of fact.
It seems you're conceding that Cody Sanford would be inadmissible under MCL 768.27A.
That's correct. We're not asking for that under the statute.
All right, and that's due to the age, correct?
Strictly the age, yes.
All right, and was there any solicitation of Mr. Sanford before age 18?
Not, we have some facts of 17, but nothing 16 and under. But there is some allegations that he was approximately 17. But that's why I argued, I think more cautiously, that it's admissible under 404B as opposed to the statute, as respect to just Mr. Sanford.
Because there are different statutes that define minor differently. Meaning in some cases it's under 16, in some cases it's under 18.
As far as just, for instance, the CSE 3s that are currently in our case, that would be under 16. But I believe the accosting, soliciting, there are certain other statutes that indicate anyone under 18 is a minor. So there is some evidence that he was approximately 17 and 18 years old. But given that, I felt safer proceeding under the 404B. Again, under the statute, I think the only conflict, again, is what the people can use it for. And I think that the conflict arises in whether or not, as far as Mr. Hill and as far as Mr. Griggs, it can be argued as far as propensity evidence. And so we would ask that that be admitted under the statute, just as to those two witnesses. Now, in the objection, I don't so much think there was a theory of defense, which I know the court can ask the defense to do after we filed our notice. But it was a general denial, essentially, disputing every fact upon every fact upon every fact. Well, when all the elements are in dispute and at issue, that weighs in favor of 404B evidence. It's People v. Sabin that says that.
So now you moved from the statute to 404B.
Yes,
okay,
yes, I apologize, I should have said that.
Go ahead.
In People v. Sabin, it's quoted as a defendant's general denial places all elements of the charge at issue, and they cite People v. Starr in that case. And it's important to note that well, there's this general denial, and there's this comment that age is the crux of our case. Age is simply an element of the case. It's the element with the 3s and the 1s, but as the court's aware, there are other elements incorporated in all 5 of these charges. So when we're talking about a general denial of age, sexual acts, general denial of all the 404B evidence, this isn't true, everything is now at issue. A general denial places that all at issue, and it weighs in favor of the evidence being extremely high in probative value. The objection really outlined just that, a general dispute to everything the people have proposed, as opposed to why the evidence would be substantially more prejudicial than probative. There was one statement in there that we failed to show how much more probative it is, but it's actually the Vanderfleet case that says that it's the opposite. The defense has the burden to show that the undue prejudice outweighs the probative value, and I just did not see how that was shown in the objection, because more or less it was just, this isn't true. So while a general denial is appropriate for the defense, I did not see anything that would show why it would be substantially more prejudicial than probative. I don't think there was even an acknowledgement that it would be probative. And I think that places everything at issue. There was also attacks on the credibility in the actual objection, which, while I think is appropriate in trial, and there are certain things that, of course, Ms. Burton will be able to question and attempt to impeach the witnesses on, I don't think it's proper for an objection where the court is the gatekeeper, for lack of a better term, on trying to determine, is this evidence relevant, is it probative, does the undue prejudice outweigh the probative? And to sort of go into this character assassination of certain witnesses saying, we dispute all this and they're, quote, liars, well, that may be something for the trier of fact to determine. We're just at the stage of determining, Judge, is this probative and is this relevant and should it come in? And I would propose that it does. There were a lot of things noted in the objection, things about Austin Williams wasn't a Fox 2 intern, and that he used the word personal assistant and we said intern. I don't really think that was relative or relevant, rather, to the argument we're here for today. There were a lot of points like that because we don't have to prove he was a quote unquote Fox 2 intern. But one thing I did note, and I wrote it down because I sort of found it a little bit unsettling, that there's this allegation or this accusation that Austin Williams is saying A, B, and C because he took it from witness Cody Sanford and he took it from Nathaniel Hill and things he's heard on the TV, to make that sort of broad statement and that accusation, but then ask the court to not allow what Cody Sanford said and what Nathaniel Hill said, what happened to them, really is a little disingenuous, because if the witness is going to be attacked as to that, didn't you hear someone, Nathaniel Hill, say this in an affidavit? Aren't you in fact making it up because of that? But then to object to say that the trier of fact is not entitled to hear what we're actually talking about doesn't make sense. That accusation alone makes the evidence even more probative, even more relevant. And that's in People v. Starr. People v. Starr talks about rebutting any allegations of fabrication. So in addition to all of these witnesses being under a proper purpose under 404B, People v. Starr says people are entitled to put on evidence to rebut any allegations of fabrication. Well, that's an allegation of fabrication, and I think that Mr. Hill, Mr. Sanford, Mr. Griggs, they all support that. They support the rebutting of that. So I think that that's really important too, and I think it makes it very probative.
Under 404B, what theory are you proceeding under?
There are several, and it's based very heavily on the two underlying theories of the CSE-1. One, that Mr. Pugh was in a position of authority and used that position of authority in a coercive manner to achieve these goals, to achieve the sexual acts. And the other theory, so it's an and/or, and we all kind of addressed this, I think, last week in sort of the motion hearings and the motion to quash, was that it occurred during an underlying felony. The solicitation, the accosting, soliciting of a minor for the immoral purposes. And part and parcel of that underlying theory is the grooming, the soliciting, the accosting.
My question is under 404B, what theory are you proceeding under?
The common plan or scheme.
Okay.
The common plan or scheme.
That's the only one, correct?
His intent, his motive in doing these things, taking these young men under his wing, mentoring them, being part of their lives, going to their families, going to their parents.
That's more of a common plan scheme,
sure,
not motive.
Absolutely. But it's how he does, and the case law kind of says it very simple, how the defendant did what he did. how he does what he does, and it's part and parcel.
Common plan and
Yes.
scheme. Is there any other theory other than common plan or scheme? You indicate absence of mistake and these other theories. Are you arguing that? I mean, you put
Not
it in
really,
brief.
and I would say it's in the brief as part of what people can introduce evidence of. I sort of included it within. Obviously, we're not doing it to show lack of consent, because we're arguing in this case,
Consent's not
obviously,
an
there's no consent.
Right.
So the very heart of it is the
so
common plan or
so
scheme.
the theory, okay, whether it's very hard, that's what you're limiting your argument to.
Yes.
Common plan or scheme.
Yes.
Go ahead.
And I think that that's really strong in the fact that the case law supports that it doesn't even have to be exactly similar in every single case, and the court knows that. And the definition of relevance isn't heightened when you're dealing with 404B. What would be a relevant piece of evidence in any other trial, it's not heightened when you're arguing it should come in under 404B. It's logical relevance, and it's the same across the board. And I put the chart in there for the simple fact of laying it out there. All of these issues of material fact, and even non-material fact, really, but that go into the common plan or scheme as far as things we don't have to prove, down the board, the similarities were overwhelming. And while there's a couple different things that didn't happen to Mr. Hill, for instance, that happened to Mr. Griggs, that's not what the court needs to look to, because there's going to be some things that are not similar.
Are you going to argue doctrine of chances?
Yes, absolutely. And that I argued the people v. Bradenbach is as far as the doctrine of chances, and it's the idea of lightning doesn't strike that many times in one place. It's the, quote, rare or unusual events that occur frequently in relation to a single person are less likely to have an innocent explanation and more likely to demonstrate the probability of an actus reus. And you're going forward, and we got this witness, and we've got this young man saying when he was 14 and 15 years old, Mr. Pugh did these things to him. He did these acts to him, and he did certain things to sort of lure him into that. Well, then you've got Cody Sanford saying a whole heck of a lot of similar things. You've got Nathaniel Hill, again, so a whole lot of similar things. And Mr. Griggs, a lot of similar things, including the acts of penetration that we have to prove in our case. And as you look at the totality of the evidence, I think we have to ask ourselves under the doctrine of chances, are these rare and unusual events are more or less likely to happen? It's kind of like, and there's a good example of it that I read in a case. A man gets pulled over and the police say he's got drugs in his car. And he goes to court and he says, I had no idea those drugs were in the car. And then, but the jury finds out and they get to hear that 5 times before that, this same defendant was pulled over by different police with drugs in the car, and he always said, I had no idea the drugs were in the car. That sort of rare, unusual event of this one man having drugs in his car each and every time, but always claiming the same thing, really applies with the doctrine of chances, making it very probative and very relevant. And I think that the testimony of all the proposed witnesses are in fact supported by the doctrine of chances. They're supported by the Bradenbach case, People v. Crawford. And the language in the Crawford case is interesting. That it says the prosecution merely has to, quote, weave a logical thread linking the prior act to the untimely inference for the trial court, for you, Your Honor. And not to sound silly, but I don't think we've got a thread here. I think we've got a rope. I mean, the logical inference linking all these witnesses together is pretty overwhelming. Of course, the court has to look at, is there the danger of undue prejudice? All the evidence that we introduce is prejudicial by nature of what we're doing in this trial, in any trial. But does it substantially outweigh the probative value? I would submit to the court it does not. And that is really something that I did not get from the objection. I can sort of get the position. I don't know what the theory of the defense is, and I would ask the court, as we requested before, if the court could ask the defense for that. But as far as I can see, it's just a general denial. So all the elements are in dispute. When all the elements are in dispute, it weighs towards this evidence coming in.
You'd agree, there's another person you haven't identified, Mr. Jason Mans.
Yes.
You'd agree that's not 404B. This is just to prove something else. As I understand it, it's to explain, why don't you
Sure.
say why you believe it's admissible and the witnesses that would support that.
And the court notes that there was a whole bunch of different names that were sort of weaved in between the statement of facts for each. So when I talk about the witnesses coming in, I'm talking more about the incident surrounding them coming in. But when we mention Jason Mans, when we mention Bill Cycley, William Cycley, a defense attorney, those are all being introduced for different purposes. We noted some employees of Fox 2 and some disciplinary actions. That's all for different purposes, but it is incorporated in it because they come up within the facts of the witnesses that I've outlined. We're talking about possible statute of limitation purposes. I know that counsel has sort of cross-examined the victim a lot about you weren't at Fox 2, you weren't a Fox 2 intern. Some of these witnesses come heavily into play as an explanation for the jury on why he wasn't officially a Fox 2 intern, but why he is still under the thumb of this position of authority. Jason Manns, the Fox 2 employees, they all encompass that.
Before you began your argument, you talked about how the employment status of the complainant really isn't at issue. It's not important. But at the end of your argument now, you're saying Jason Manns is important to explain the Mr. Williams' employment status.
And I understand what the court's saying. It's in the issue of rebutting what counsel is putting out there. Position of authority is not saying you have to explicitly be an intern and a boss at an employment place. Position of authority, the reason I stated it in the beginning, is position of authority is wide.
So you're looking at it, this is more rebuttal evidence.
Correct. And the issue is we've got counselors, we've got teachers, we've got church, people in the church, all encompassing what the theory of position of authority is. So that if the trier of fact is hearing, well, you were not officially a Fox 2 intern, it also explains some of the questions counsel was going after the victim about certain, well, you're a personal assistant, but you're doing X, Y, and Z, and you're not at the news station, and you didn't sign a contract. There is a whole bunch of evidence to be introduced through those witnesses on why Mr. Williams was not present at the Fox 2 studio, why he did not sign a contract, why at the time Mr. Pugh was not to have interns at the Fox 2 station. So, and the reason it's in there is because it's tied in part and parcel to other acts, to prior acts. That's the indication of Jason Manns and why he's mentioned in the brief.
All right. Response?
Thank you, Judge.
Yes, thank you, Your Honor. Ooh, does there a lot to say? Bear with me. First of all, Your Honor, as it relates to the amended notice, while the prosecutor indicates that, oh, we found out after court that Mr. Griggs was a part of this, when I received information from her by email was when I left court, it was already in the form of a brief. So it was already a notice that had been filed. And I don't think that they filed it within that hour that we left court. It's my understanding that that information was known earlier in the week at least, because Mr. Elizondo indicated that we were going to add some additional information, but we chose not to. When this court indicated that it needed some additional time to review the notice and gave us the additional week, that's when it was added. And so when we talk about who's being disingenuous in terms of giving information, that's just certainly not true in terms of when they learned about Mr. Griggs. Nevertheless, let's deal with Mr. Griggs. Now, I'll start with Mr. Griggs first. Mr. Griggs was an adult. According to the information that the prosecutor has given, Mr. Griggs was purportedly seen Mr. Pugh downtown. His mother was working in the mayor's office, and they said it was Mayor Archer. Mayor Archer was mayor of Detroit, I believe, from 1994 to 2001. In 1993 is when he was elected, but then he sat in 1994, and I believe it was until 2001. We know prior to that time he was a Supreme Court justice. Nevertheless, if we look at the time frame, and one of the things I have a habit of doing is asking the prosecutor what was the age of certain individuals. And so we did have an opportunity to meet on Wednesday concerning discovery issues, Tuesday concerning discovery issues, and I was given a calculator regarding Carl Griggs. Mr. Griggs was born May 9th, 1978. Well, in 1993 he was 15 and claims that he met Mr. Pugh at a club, and then he said he was there to have lunch with his mom. Well, in 1993, Mr. Pugh was not even in the state. And again, you say, well, that's evidence that you could submit, but it's information that they already have. What they did was they requested or subpoenaed the file from Fox 2. And it indicates that it wasn't until 1999 that Mr. Pugh submitted an application with Fox 2. And let me see if I can find it, Judge. Hold on a minute. I believe it was June of 1999 that application was signed. So, 6/22/99. So at the time that they're claiming that Mr. Griggs was supposed to be 15, he wasn't even working with Fox 2. And he wouldn't have been downtown interviewing anybody because he wasn't even in the state. And that application also lists the dates of where he was. And he couldn't have just created that now because that's information that they had and it's dated 1999. So that meant in 1999, Mr. Griggs, according to this calculation, he would have been 21. In 1999, he would have been 21, and just to say that it was that year, he would have been 21. So, it would behoove the prosecutor to try to get some dates. All they say is, somebody said that they were 14, or they said that they were 15 at the time, without actually determining how old they were. And if he's an adult, then that takes him certainly outside the realm of the argument that they're making in terms of under 768.27. You can't have it both ways. You want to argue and say, he's grooming, he's soliciting, these people. You have adults in some of these cases, Judge, and it's sad that, that's not known. And I got the information from them. It's in his employment file, so I'm not making that up.
I was going to say, I was unclear in people's pleadings when they say this meeting between the defendant and Mr. Griggs occurred. When was that?
And, Your Honor, and I had some follow-up. Our investigator had some follow-up questions for him, and I had to file the notice quickly. I can give you the information that I have. He indicates he met Charles during his sophomore year / junior year. He believes, and it was his remembrance, that Mr. Pugh was in town for the holiday but had not moved back to Detroit full-time. He said that he was born May of 78. He recalls it being around December of 93 when he was 15 years old. He indicated he met him, and these acts all occurred before May of 1994 when he would have turned 16. I never said that he was interviewing for Fox 2. Mr. Griggs states he was visiting his mom, but he was there interviewing the mayor. I don't know where he was working.
I don't want to go back into argument. My
Sure.
only question is this alleged contact with Mr. Griggs, you're saying you will produce evidence that he was 15, perhaps as old as 16, when that contact occurred. Is that correct?
Well, he's going to testify to that.
That's evidence.
Yeah, absolutely, yes. And he's...
Okay, that's all I needed
Yes,
to know.
absolutely.
Back to your argument. I'm sorry, go ahead.
Okay, and so, and with that, now it's changing, because in the amended report, they wanted to say that Mr. Griggs, just like, I believe it was, one of the other gentlemen, worked doing assignments for Fox 2, and he asked him to be an intern. And see, it begins to change every time that, there's another hearing, because this quote-unquote theory of internship, it originated from the prosecution's arguments at the preliminary examination. That's not something I created. Judge, that was the format that they laid at the preliminary examination, and I simply took it and questioned the witnesses about it. I never said anything about the intern because we knew he wasn't an intern. So now, because the internship didn't work in the way that they wanted to, then it began to shift to personal assistant. And I know the court said, well, that's not the primary issue, is it the position of authority? But I want the court to know why it's being addressed. It's being addressed because they were the ones that initially laid that foundation. And I have a right to cross-examine them, and I have a right to challenge what they say. So that brings us to Mr. Griggs in terms of his age, and it's already in the documents that they have with respect to him being out of town. I was not given any follow-up information, now, since they know his age. But if we're looking at the years of employment and years of when he purportedly was solicited, it just doesn't comport with him being 15. He said he was in a bar, or he met Mr. Pugh at a bar, which would indicate that he's probably older. Why does that become important? Because they're talking about character assassination of their witnesses. That's exactly what they're trying to do to Mr. Pugh. This has nothing to do with what's relevant and the proper purpose. It's all about the propensity, and I understand the statute in terms of it trumping the court rules, but, you still must move to the balancing test. You still must subject the evidence to 403B. Whether it's relevant or not under 401, you still have to move to 403. And I think that that's where we get the problem. The evidence then becomes confusing, Judge, because you have all of these outside factors. I've tried cases where it's 3 and 1, and you have these multiple, people parlayed in and saying this and saying that. And what it does is it's confusing, because you try to tell the jury, you need to compartmentalize this, and yeah, you only use it for this purpose. And what they did was they spewed out everything in the court rules in terms of, motive, intent, absence of mistake, all of these things, and then, of course, when the court narrows them down, it's like, it's regarding a common plan and scheme. We're going to just stick to that. But they say all these things and then say, I don't know why she really brought that up or why she addressed that. I addressed it because that's what was written, and I responded to it. And so let me respond in this way. Mr. Griggs was older, and we will, of course, have information to indicate that Mr. Pugh was not in town during that time, and that he can't have it both ways. He can't say, I'm down there and my mother's working for the mayor, and they say, okay, well, he was trying to become an intern, and they even say he asked him to be an intern. And if he's purportedly asking to be an intern, then that would imply, which they said, that it would have been with Fox 2, which meant he was much, much older. So why does that become important? Because the court still has determined if there's some indicia of reliability in terms of the evidence that's being offered. You just can't say, okay, it's relevant, but is it reliable? Truth, is something that's settled, I guess, in terms of by the trier of fact. Veracity is determined, but the court still has to look at, if I admit this evidence, is it reliable based upon what limited information we know? So some of the things that the court can look at, you can look at the dissimilarity between the acts and the charged crimes. The court pointed it out as it relates to Mr. Hill. No allegations of any type of penetration. As it relates to Mr. Sanford, no allegations of any type of penetration. And as it relates to Mr. Griggs, I just gave the court the rationale as it relates to that. The information that they even submitted, the documentation, doesn't support what they're saying.
I mean, in one sense, since there was not an allegation of penetration, it's a dissimilarity. In the other sense, it also reduces the prejudicial effect to your client.
Reduces it? Well, if the court admits it, you still have him coming in and saying certain things. And I think that's what's problematic. When you allow 3 people to come in, you just can't narrow it, because then you're going to limit my cross-examination in terms of what I can ask these individuals about. And I want to be thorough, so if you talk about these instances purportedly of grooming, then I would assume that they're saying that this is more than one occasion. That's contrary to the cases that have been submitted, because most of that has been somewhat narrowly tailored to, you could have a specific instance. Is it on Christmas that, in Watkins' case, he's with his stepdaughter? You have specific instances in terms of the acts occurring. When you have this broad picture being painted of this enticing, soliciting, accosting, then where does it end? What parameters can the court set to say, well, you can't ask that, was it on a Tuesday? Was it, during the holidays? Because then you get into trying trials within trials. That's not the purpose of the rules. There are times when that information is admitted, but the court, again, has to look at the prejudicial effect. And I will submit to you that it's confusing. It becomes confusing because there are no parameters that the court can set. There's no limiting instruction that would be sufficient to cure the harm that would occur from allowing 3, 4 people to, come in and say, oh, he did this, he did that, especially when these individuals are 16 years or older. I understand the problems we have with the statute, because you have some instances where a person has to be 18. And it's sad that there's no true consistency. You have to be 21 in order to buy alcohol, but you have to be 18 to vote. Yet, if someone's 12 years old, they can be waived over to an adult on a capital offense. So it's no true consistency there. But what I submit to the court, the case in the case in chief, is that they're alleging that the individual, Mr. Williams, is under the age of 16. That's really, what the statute is about. There are other elements, but, that's a primary issue or primary element. That being the case, then if these other individuals are older than that, then I think it poses a problem because you have adults. You either have a person who has the ability to consent to an act which they're saying is improper
But at
or
least
illegal.
I guess the point I was trying to make is, in the event that they are adults, then it just comes to the issue of sexual relations with two consenting adults. And whether, and the people would argue, they may be consenting adults, but it shows a common plan or scheme of targeting youthful-looking individuals.
You know what, Your Honor, I think you're on a slippery slope when you look at it that way. Real slippery slope. Because then, you're saying, well, they're adults, but we're going to bring them in because none of these people are saying, I didn't want this or that to happen. You have Cody Sanford. That's a civil matter. There was a 1983 action that was brought. There weren't any criminal charges. And one additional things the court can consider is the lack of evidence that supports the other act's evidence. All we have is statements. We have an affidavit from Nathaniel Hill. And let me focus on Nathaniel Hill, what he's all about. Yes, I am going to challenge his credibility because when he was, quote unquote, the personal assistant for Mr. Pugh, he stole some checks. And when he stole those checks, he generated his own, so he stole a check, and he generated his own information, and the fraudulent checks were used to deplete the account of some people that Mr. Pugh was dealing with. And the prosecutor was aware of that because they called Mr. Pugh at the time and said, hey, we saw your name come up. How did your name come up in this? So that young man was being prosecuted at 16 for that. And that's why the prosecutor didn't want the information regarding his juvenile record to come out because he wouldn't have been 17, and because it was not a capital offense, he wasn't bound over on it, but he was, in fact, 16 at the time that he was prosecuted for that. So, when they come in and they bring these people, at least let them come in with clean hands. They come in and they make these allegations, and then they themselves have all kind of problems. When they got the affidavit from Mr. Hill, that was during the trial, or preceding the trial of Mr. Sanford. It was preceding the trial of Mr. Sanford. But he was in prison. He was in Chippewa prison serving for carjacking and robbery. I think the robbery might have been dismissed, and he ended up going on a carjacking and ended up going to jail for impersonating a police officer. So, look at who they're asking to bring the information in on. Plus, there's no other evidence to support that. Now, you don't necessarily need corroboration, but one of the things the court can consider when you're looking at this other act's evidence is what else is it? Cody Sanford, you had a police report that was filed on that. There's nobody else with respect to the police report outside of Mr. Williams, so I'm talking about the other acts, that has anything else to support that. All I have from them that relates to Mr. Griggs is just a statement that they put, their whole statement, her whole statement, that was put in the amended notice. I don't have anything else, and it's my understanding there's probably not anything else that relates to any reports. So when you talk about, they could admit uncharged acts, but, what else can we use, based upon the fact that the allegations are, quote unquote, years ago, for these people to just, be parlayed in here and say, oh, in 1993, I remember it was this, because then, yes, it does come down to just credibility at that point, because there's nothing else. I don't have a transcript, I don't have a police report, I don't have a statement, I have some pleadings, but I can't cross-examine Ms. Bennett. And so what else is it? I think you need more, Judge. We just can't say that, oh, it's relevant, or it sounds good, it sounds like a plan. What else supports that? And yes, I do have an opportunity to cross-examine, but it would be helpful I had something to cross-examine with. And so when I say prejudicial, it is prejudicial because it's confusing for the jury to allow any of this evidence in, considering the fact of these witnesses. And let me touch upon this issue relating to Fox 2 and Jason Manns. As I indicated in my response, that was an employment-related dispute. This is not an employment-related dispute. There are different standards. We're in a criminal case, and the penalty here is severe. And so if we're dealing with employment-related issues, it has nothing to do with an intern. All he's trying to do is exercise some sort of smear campaign and taint his character. This is nothing about stuff being offered for a proper purpose, because they know that he had interns subsequent to that time. He had interns during his entire tenure at Fox 2. And some of those interns have worked for Channel 2, Channel 4, and Channel 7. And Mr. Manns, in terms of that relationship, it wasn't Mr. Manns that was complaining about anything, because Mr. Manns and Mr. Pugh were friends. As a matter of fact, Mr. Pugh was the individual who secured that internship for misdemeanors. Yeah. And that information regarding misdemeanors is also in the information that I would receive from them because he's listed as one of his beneficiaries. And so that relationship, that existed, it wasn't anything that was not wanted. This was a close friend of his. Yes, he took him to work. So what? You take people who are close friends to work. You put people's pictures up who are close friends. It's done everywhere else. But because, of this homophobia that people have, then, unfortunately, certain things aren't looked in the same way as if you have a man and a woman that's on the wall or posted. And that's unfortunate.
I was going to say, I think the only reason why they are talking about Mr. Mance, or at least the only reason why they've indicated they're talking about Mr. Mance, is to somehow explain the complaint, the charged offenses, employment status, or lack of employment status, and the reasons surrounding that.
Just you're talking about 3 years. That letter is dated in 2000. And then we're talking about the allegations that are being made by Mr. Williams either in 2003, 2004. And so, but, we can present witnesses to show that they did, in fact, have interns prior to these allegations by Mr. Williams and subsequent to those allegations. But, so you can look at space and time, temporal proximity. Those are things that the court can consider as it relates to all of the allegations, not just what's happening at Fox 2. My thing is, Judge, that, you really have to be careful when you allow this other information in terms of not being confusing. And one of the things that Watkins did point out, it says, even though the statute might trump the court rules, it doesn't negate the fact that the court still has to, exercise some degree of scrutiny under MRE 403. And it becomes up to the court. It's really within your discretion. And certainly we ask this honorable court and implore this honorable court to exercise that discretion in favor of Mr. Pugh. Judge, again, we are saying that these individuals are not being forthright about what has happened. That is true. And we will, again, present our witnesses just as they are going to present their witnesses. But as far as bringing this other information in to the trial, you have a 3-in-1 trial. You have the differences as far as the allegations that have been brought forth. When you say it will minimize the prejudice to your client, no, Judge. That information coming in because it's not just going to be limited to, say one instance. And while the court has allowed them to proceed on this theory, quote unquote, of costing, soliciting, and enticing, it's a dangerous road to go down. And I say dangerous because where does it end? When you open up Pandora's box and you allow each of those witnesses to testify to quote unquote specific instances of this alleged grooming, then where would it end? You would have trials within trials, and remember, he's not charged with that. That's a theory, and I understand the court's rationale in terms of them still being able to use that. However, I think it's dangerous, and it is more prejudicial than probative. This is nothing more than to show propensity and to smear the character without really focusing on the issue specifically relating to Mr. Williams. And then lastly, I'll address this doctrine of chances. The doctrine of chances is nothing more than a theory of probability. That's all it is.
I wouldn't spend a lot of time on that one.
Okay, all right, well, I'll take the court's note and I'll have my seat. Thank you.
Okay.
Judge, may I very, very, very briefly
2
respond
minutes.
just to a couple of things? And I know Ms. Burton was talking about Nathaniel Hill and these things when he's 16, and the people don't want that to be brought up. That's not the people. That's Michigan Rule of Evidence 609 when it talks about what you can impeach on as far as prior convictions of crime. And subsection E indicates juvenile adjudications.
Yeah, that's a collateral issue.
Right.
For this motion.
And so I just wanted to address that. As far as Mr. Griggs, what I had said to the court when I first started was we became aware of what he would say, the facts of his case, not until Friday. Of course we knew the name of Carl Griggs. He's on our witness list.
That's a collateral issue.
Okay,
For this motion.
and I just want to know that that's when we put the information out there. Never said that, as far as clarifying the dates, I think we did that already when the court asked me questions about that. And again, counsel said it was this theory of internship. It's not. and I know she keeps saying internship, it's this position of authority, and I don't want that to get confused. Talking about Mr. Williams changing his story, and he has maintained all along intern and personal assistant were interchangeable to him, that Mr. Pugh held himself out under the impression that he was going to be a Fox 2 intern. It quickly became apparent to Mr. Williams that he wasn't. So that becomes really important, and that, just like the court said as far as Mr. Manns, the court knows what our purpose is. One additional note is it also shows Mr. Pugh's knowledge, what was in his head when he held himself out to Austin Williams. Austin says, can I be an intern? Sure, here's my number, give me a call. Goes on a couple Fox 2 related events, but doesn't bring him into the studio. That shows what's going on, the knowledge that's in the defendant's head when he holds himself out to this 14-year-old, you can be my intern. But I don't think that term personal assistant, because Mr. Williams has used that term many times. And counsel says that all we have is their testimony, and that's it. We've actually noted in there, too, that at least for two of the witnesses, their moms could become witnesses as far as Mr. Pugh met Mr. Hill's mom. He met Austin Williams' mom. He spoke and got permission from Cody Sanford's mom to take him shopping for a suit for an interview. So as far as Cody Sanford, and I appreciate what Ms. Bird says. Sometimes minor is under 18, sometimes it's under 16, and I get it and I agree with her. There should be some sort of clarification on that. But we're not talking about the fact that he was of a certain age, so it's okay. He was still in a mentorship program with the defendant. As far as Jason Manns, they're friends. He's a beneficiary. But she has the document showing that he was disciplined because he was in an authority position over Mr. Manns, and that you can't have this relationship with Mr. Manns working there. So again, it always goes back to the authority and the coercion with that. So I will leave it at that and ask the court to rule in our favor.
The defendant's charged with criminal sexual conduct in connection with the complainant Austin Williams. While Williams reportedly worked for the defendant as a personal assistant. At the time of the alleged assaults, complainant Williams was 14 to 15 years old. The prosecution has filed a motion of intent to use other act evidence under MCL 768.27A, 404B, and the Doctrine of Chances to admit evidence of sexual advances or assaults with three other teenage boys that allegedly occurred before and after the charged offenses. The defendant has filed an objection. In the case charged, Austin Williams was 14 to 15 years old in 2003 and 2004, attending high school when he first met the defendant. According to the complainant, he began working for the defendant as a personal assistant after he obtained position from his mother. Parental permission is something that the defendant insisted on. The people argue that after personal access was given, the defendant exploited his position of trust to employ a common plan, scheme, or system to groom, solicit, entice, and in some cases assault his victims. According to the people, the defendant groomed complainant Williams by touching him, then showing the complainant pornographic videos. It then escalated to the point of masturbation and eventually sexual penetration, all before Williams' 16th birthday. In doing so, the people argue the defendant used his celebrity status, the prospect of getting a job, his parental supervisory position, isolation from other adults, the giving of gifts, and general flattery to commit sexual assault on a minor. The other complainants are as follows. Sometime after 2004, Nathaniel Hill began working for the defendants as a personal assistant for about a year. At the time, he was 14 to 15 years old, and the defendant argues he was 16. His work was primarily doing household chores and odd jobs for the defendant. Like Williams, the defendant would reportedly flatter Hill about his personal appearance and tell him how beautiful he was. Mr. Hill saw pornographic videos at the defendant's house between young men. The defendant then began a conversation that people watch pornography to masturbate. During this time, the defendant made allegedly sexual advances toward him. According to the prosecution, the defendant encouraged Hill to text him sexually explicit photos of himself, which he did. Defendant apparently insisted on seeing more, but Hill refused. Thereafter, Hill rebuffed defendant's sexual advances and within a month of sending the photo, defendant, Mr. Hill, I should say, was terminated. The people imply this was, at least in their pleadings, was because Hill was non-compliant. Defendant claims this was due to Hill stealing from the defendant. So under the statute, the question is a primary question, at least for this court, is whether accosting and soliciting a minor for immoral purposes is a listed offense under the statute. Here, under the Sex Offender Registry Act, that crime is a Tier 2 offense. Therefore, under the statute, it is a offense that would be covered by the statute. The second witness the people intend to introduce at trial is Cody Stanford. That's K-H-O-D-Y, Stanford. In the spring of 2013, Mr. Stanford, make that Sanford, was a high school senior and a member of Detroit's defendants' mentoring program located at a school. Defendant learned Sanford needed clothes for a job interview and offered to buy them. Defendant called Sanford's mother for permission to take him shopping, which was given. Once there, defendant allegedly repeatedly touched Mr. Sanford's waistband on each pair of pants he tried on. And during the ride home, defendant allegedly touched Mr. Sanford on his upper thigh, which was rebuffed. Sanford assumed that this was an effort to gauge Sanford's sexual interest. Later, Sanford needed money for the prom, and defendant allegedly offered to pay Mr. Sanford the money needed for a hotel room for prom, but said it would come at a price. Specifically, defendant requested Mr. Sanford to film himself masturbating and text the video to the defendant, which the defendant did. I should say which Sanford did. Sanford's mother allegedly learned of the video, and text and contact terminated. Defendant alleges Mr. Sanford was 18 years old, so not a minor, and defendant did not coerce him into the acts that Mr. Sanford engaged. With regard to this crime, the people are not arguing that it be admitted under MCL 768.27a because of the age of Mr. Sanford. I would note that the people did say, however, that some of the acts occurred when he was 17. It's worth noting that child sexually abusive activity of a crime applies to complainants who are under 17. And that crime is listed as a Tier 2 offense. Therefore, Mr. Sanford arguably would fall under the statute as well. However, the people do not argue that it be admitted for that purpose and should be evaluated instead under MRE 404B, which the court will do. Lastly, Mr. Carl Griggs is asked to be also allowed to testify at trial. Mr. Griggs allegedly met the defendant when he was 15 years old, and that contact continued when he was 16. That issue was in dispute as evidenced in the hearing today. According to the people, there was evidence that the defendant allegedly tried to recruit Mr. Griggs for work as an intern. They met about a week later approximately a week later, and the defendant then took him to a club where he consumed alcohol. The defendant then allegedly took him back to a relative's house where masturbation and oral sex occurred. MCL 768.27a allows for the admission of other sex offenses committed against a minor, provided that it is relevant. That is, again, MCL 768.27a and People v. Watkins 491 Mich 450, 2012. The analysis of whether the other act's evidence is admissible begins and ends with the statute, even if the relevancy is to prove propensity. Here I find that the sexual allegations involving Mr. Hill and Mr. Griggs are admissible under MCL 768.27a because they are relevant to show a common plan or scheme of the defendant allegedly targeting teenagers in high school and using defendant's celebrity status his mentoring program, and the possibility of employment to obtain parental consent, and then using that parental consent and that isolation to allegedly commit sexual offenses against minors. In each of these cases, the defendant allegedly propositions a high school student to have sexual contact and then solicits photos or pornographic videos to be sent as a precursor for sexual relations of some kind. Also, when reviewing People v. Watkins, I do not find that the relevancy of this issue is substantially outweighed by the danger of unfair prejudice. Therefore, I will allow the people to admit testimony from Mr. Hill and Mr. Griggs under that statute. Now turning to Mr. Sanford, I would note that as it relates to Mr. Sanford as well as Mr. Hill and Griggs, I would also find that those witnesses are admissible under 404B for the same reasons I've already stated, under a common plan or scheme. As I mentioned earlier, there is evidence that the people intend to prove and evidence that exists that the defendant allegedly targeted teenagers in high school and uses his celebrity status and mentoring program and opportunities to obtain parental consent and then use that consent or status to allegedly commit sexual offenses against minors or very young adults. In each of these cases, there is a proposition to a young adult in high school to have sexual contact and then solicits pornographic videos or pictures as a precursor to sexual relations. I do recognize that evidence under 404B of other crimes, wrongs, and acts are not admissible to show a propensity to commit a certain crime, but are admissible for other purposes, such as common plan or scheme in doing an act. Under Vanderbilt, there's a four-part test to be applied. First, it must be offered for a proper purpose. Under MRE 404B, it has. Second, that the other act's evidence is relevant. I've already gone through the factors to show that it's relevant. Third, that the court must determine that its probative value is not substantially outweighed by the danger of unfair prejudice, and here I do not. Here, the evidence in, I believe, 2 of the 3 situations do not even involve penetration, perhaps grooming at most, but I do not find that any prejudicial effect it has is unfair. And if asked, I would provide a limiting instruction if drafted by the defense. For those reasons, I will find the proposed 3 witnesses admissible under either the statute or 404B. I would like to talk about Mr. Griggs. With regard to Mr. Griggs, the testimony there is to rebut an expected argument by the defense that the complainant in the charged offense was not an intern or was not an employee. It is not being asked to be admitted under MCL 768.27A or under 404B. The issue here is whether, the threshold question is how important is it, how relevant is it, is about the complainant Williams' employment status. And everyone here seems to agree that it's not important. It's the position of authority that's important, not whether he was an intern, an unpaid intern, whether he was an employee at will, or whether he was a gopher who was a personal assistant that had little, if no, contact with Fox 2 News, at least in an official capacity. It's just not relevant. His employment status is not relevant, and the facts that flow from that are likewise not relevant. Therefore, for a lack of relevancy as to Mr. Griggs and a potential of unfair prejudice.
Judge, I don't want to interrupt. Do you mean Mr. Mann?
I'm sorry, Mr.
Okay,
Mr. Mann.
Sure.
That's right, M-A-N-N-S. Therefore, due to the risk of unfair prejudice for Mr. Mann's as well as some of the other issues, I'm concerned that there is a risk of confusion. Its probative value is very slight, and its prejudicial effect, in my judgment, would exceed any probative value. Therefore, Mr. Mann's testimony and witnesses in support of that are simply just not relevant. What I'd like to do now, I'd like to turn to a different issue. When this case came to me early on, I noted that there was an order in the court file. That order in the court file was authorized by a district court judge sealing the court file. I looked in the court file. There's no motion that was ever filed, that I could see, at least in the court file. There was no hearing that I saw that was ever filed. There was no response that was ever filed, which leads me to believe that an order ex parte was given to the judge that was signed. I expressed concern about that when we were here last, and I indicated that I'd give the parties until today to file any motion that would justify this court to continue the seal. As I understand it, that has not been filed, correct?
That's correct, Judge. And I think the only thing, maybe I'm confused, I don't think the order was, and there might not be a difference, to seal the file versus, I know there was an order to suppress the investigator's report and the witness list to protect the victim at that time's name and to protect the integrity of the charges and all that at the time. I don't think we requested that the actual court file be sealed. I don't know if that's different, but I don't think that we would be requesting that today.
Okay, so that proposed order was drafted by the people, correct?
Yes,
all right.
It was. And I would just ask that the investigator's report and the witness list stay suppressed, but I would not ask that the court file be sealed.
What's your legal justification for that?
I think the continued protection of the victim and the witnesses. I will say there are some names on the witness list that I think that the media should not have at this point in the game until we actually call them and present them as witnesses at trial. I will leave that to the court's discretion. I just don't think we need to seal I don't think we would have anything to rise to the level to ask the court to seal the actual court file.
Have you ever, in your other criminal sexual conduct cases that you've handled, have you ever asked for this order before?
Many times before. On every high-profile media case we ask for it. Whenever there's media attention on it, it's pretty much a standard thing that we request at the arraignment of the warrant. As soon as the person's arraigned on the warrant, we send it with the officer. So it's standard. It is something we standard do.
I just identified the minor witnesses.
I understand.
What other witnesses would you not want to be disclosed?
We'll leave it to the court. We'll leave it to the court.
Do you see what I'm saying?
I do.
The minor witnesses have already been identified in
Right.
pleadings that you've already identified is not suppressed. So anyone can take a look at the court file and see the names. Other than the minor complainants who are already been discussed in open court, what other witnesses would you not want the media to see?
Nothing. We'll defer to the court's judgment on that. We understand what the court's saying.
All right. Any objection?
Well, no, Your Honor. I mean, the names have already been revealed on TV and on the media, so to suppress it, I don't know that it serves any real value because the names are already out. Furthermore, all of these individuals are now adults. So.
All right. All right. In light of that, I'm lifting any seal, any limitation on the file, and an order will be entered to that effect today.
Judge, as to that issue, the only thing I'd ask is any identifying information as far as address of the complainant. I think the Crime Victim Rights Act protects that person from having that information made public. So,
unless you put it on your witness list? Is it on your witness list?
No, it's not. It's put
then
in.
It won't be in the court file.
Okay. I just wanted to make sure of that.
Okay. All right. Anything further?
Oh, I do want to address the...
Oh, there was one other issue. It's my standard practice in cases to set a cutoff date for pleas, and that way I can manage my docket more effectively, that I don't have cases that are scheduled for trial that aren't going to be trials. I don't know what the status of any discussions are. I don't need to know what the status of any discussions are, but I would like to set a date. What's a reasonable date to set?
Given the upcoming trial is fairly soon, my opinion would be next Wednesday, Judge.
Seem reasonable?
That's the reason.
All right, that'll be our plea cutoff date. And should we set it for Wednesday?
I think we should.
We can schedule.
All right, well, why don't we do this? Let's not set it for Wednesday. If it looks like it's gonna be something other than a trial, notify the court and we'll see each other next Wednesday.
Okay,
That's fair.
that's fine.
Thank you, Judge.
All right, thank you.
And Your Honor, as it relates to the issue regarding discovery, I do have most of the information. I did meet with Mr. Elizondo and Ms. Bennett on Tuesday of this week. I did have an opportunity to review their file. There's some information that I do have, but I believe there's still some information that's going to be provided, and I believe Mr. Elizondo indicates he will get that to me maybe later today.
That's correct. If there's some DVDs that need to be copied, and I showed those to council, they'll be copied and ready for by the end of the day today.
All right, that concludes the matter. Thank you.
Thank you,
Thank
Judge.
you, Your Honor.